and the bill that came forth and is now law basically says that as long as a person passes a background check, as long as they get some minimal amount of training, I still don't think it's enough. We're in a building where every single day police officers are being trained and retrained on how to professionally and competently use their firearms under extraordinarily stressful, difficult situations. And nobody should take that lightly. That's the fundamental issue. Almost once a month, sometimes more, I personally respond with my investigators to what we call a use of force incident. That's when a police officer confronts a situation where they feel obligated to use deadly force to stop somebody from committing a crime or endangering somebody's safety. We investigate those very closely, and we put those officers through a very rigorous process to make sure that they made the right decisions each step of the way. And you got to remember that they've had hundreds of hours of training before they've ever had to use that in real life. And you talk to any of them that have been through that process, and they'll tell you that it's something they'd never want to do again. If they weren't required to do what they did, they would never want to be in that situation again. That's just how difficult it is. So my only urging and advocacy tonight is that I have no problem with people that want to have concealed carry permits. I am not against that. All I ask is that people understand what an awesome responsibility comes with it. And what I strongly suggest is that you work closely with the people that you've developed relationships with the police department itself, and you talk to them about it, so that they know if you're permitted. There's probably nothing better you could do than get to know your local police officers, so that they would know who you are, and they would know if they encountered you in public that you were in fact a permitted person. So the basic law, I've just explained what the basic law entails now. So we are now a shall issue state. If you pass the background check and you receive that training, the minimum training requirement, the state is obligated to issue a concealed carry permit. We are now in, I think, month 3 or so, 4 of this law being in effect. And there's something else I predicted, and that is that you would get an initial rush of people that wanted this permit. People that had just were dying to carry around a big chunk of metal on their hip for a long period of time. They wanted that very badly. And so that's exactly what happened, is you had a big rush of applications for the first 2 months. The Department of Justice couldn't even process them quick enough. I also predicted that after that initial rush was over, that it would start going down dramatically, and from that point on, you're going to get a couple thousand a year, is how I predict it'll happen. So it's like anything else. Once people actually do something, they realize that it might not be everything they thought. It's sort of like a Christmas present. After you've gotten it and you've opened it up and you've played with it for a while, sometimes it loses its luster. Okay, so that's what I think is going to happen, and that's what's happened in most states. Having said that, the world has not come to an end. I still believe strongly that we need to tweak this law to make it better. There's some aspects of it that I think just don't make a whole lot of sense. You know, something that doesn't make sense to me, for example, is a person that's eligible to be charged as a habitual criminal. You know, they've had three criminal convictions within a 5-year period. As long as it's not a felony, they're still eligible to get a concealed carry permit. You could have 3 concealed carry or weapons-related violations that are misdemeanors, and you can still get a concealed carry permit. There's just a number of laws. There's some laws that actually make it a criminal offense for police officers if they act a certain way during an encounter. They don't allow police officers to carry concealed weapons within a school zone unless they're in their official capacity. Things like that just don't make sense, and that's what happens when bills are kind of rushed through and people don't listen to the professionals that have dealt with the issue for a long time. But that's fine. Like I said, it's not the end of the world. We're going to handle it. So the other important thing to understand is that you now have really 2 categories of understanding how it impacts, and that is there are still locations that are strictly prohibited for anybody to carry a concealed weapon except a law enforcement officer. Those are courthouses, those are schools, those are mental health institutions, locations like that where it is still strictly prohibited, even for a concealed carry permittee, to have a concealed weapon. So you have to be aware of it. The second category, it's not, those are not prohibited places, those are posted places. So it's really the two P's. It's either prohibited or it can be posted. And that sometimes affects members in the community more, particularly if you're a business owner, if you're a landlord. You oftentimes have questions about, can I post on my location, and what does it mean to post, and what's the consequence? Posting simply means that if you own a property, whether it's a business or your private residence or a church or anything like that, you have the ability to exclude people from carrying concealed weapons. The law, by the way, expands what's considered a concealed weapon now. It's not just handguns anymore. It also includes electric weapons, and it includes what they describe as clubs. So you can now carry a club, an electric weapon, a knife, or a handgun. So there's really 4 types of weapons that if you have a permit, you can carry. And that's important to keep in mind too, because in effect what it's done, it's legalized the use of electric weapons as well. You still can't sell, it's still a felony to sell electric weapons in the state of Wisconsin, but you can now possess them. And if you're permitted, you can even carry an electric weapon concealed. So what has not changed dramatically and still creates some problems is that, again, remember, over 100 years we developed case law that would help officers understand under what circumstances they could recover a firearm and whether the recovery of that firearm made it a criminal offense. Cars. Okay, so the Milwaukee Police Department, help me out, how many traffic stops did the Milwaukee Police Department engage in 2011? Something like 60,000 more? It was a lot.
More.
It was more.
Yeah.
75.
Hundreds.
Maybe hundreds. It could even be more than that. Okay. So one of the most common ways that a police officer encounters people in the public setting is in a traffic stop situation. So for over 100 years, when police officers stop somebody in a car, the understanding was that if that person, if the officer became aware that the person had a weapon, it was almost per se, unless they were law enforcement, it was almost per se a concealed carry a crime under those circumstances. That still remains true. If you do not have the permit and you have a concealed weapon in the car, it still remains a Class A misdemeanor. What's difficult for police officers, you can understand how in trying to work this out in real life circumstances, how it creates a problem for police officers. And that is, in that initial phase that they're encountering a citizen and they think the person might be armed, they've been trained forever to take certain actions to make sure that they keep the situation safe and they keep themselves safe. And so what we have to really work on as a community is figuring out effective ways for police officers to identify the people that have concealed permits and to be able to still do their jobs in a safe and effective way. And so that's one of those areas that still remain a little bit ambiguous. And I know, and I've been working with the Milwaukee Police Department on looking at all the different ways that they can do that and do it safely and do it legally. And that's their commitment, and that's our commitment. And that is that our job in the end is to respect people's civil rights, but also to keep people safe. And it's always balancing those two things that is the biggest challenge to police officers and prosecutors. It's just making sure that we balance those two issues as effectively as we possibly can. So that's a short history of where we are right now. I still, my position is that we still have some work to do. I would still like the legislature to follow through on some of the things that we brought to them and ask them to fix certain aspects of the law so that it could be even stronger. My position is it should be a model law. I mean, we had the opportunity to do it. We had the experts with the knowledge of how to do it, and I felt strongly that we could have come out with a law that would have met everybody's needs and really have been a model law that would have given law enforcement the tools they need to do their job and still respected people's civil liberties and their ability to carry a concealed weapon if they chose to do so. So Let me stop there and just ask if anybody has any general questions about the law and about how it's been going so far. Please.
How does this law affect households that have sons or daughters that are felons?
You know, that's always been that's a great question, and the reality is that it creates ambiguity, and it always has. So, for example, if you're a lawful, you know, not lawful, if you have no record, but you have son, daughter, relative who's living with you, who's a convicted felon, and there's firearms in the house, it's always, we've encountered this in certain circumstances where there's also a prohibition on what's called furnishing a firearm to a felon. And so if it's accessible to that person, and you know it's accessible to them, and you don't do anything to keep it away from them, you face potential liability for that. Now, it's very rare that we've actually prosecuted people for doing that, but my advice is that if you have somebody that's a convicted felon, that has not changed at all. So if you've got somebody
I'm a private detective for 24 years.
Sure.
And I've been carrying, because I've had my training and everything for the last 24 years. And my son is a felon. He stays with me. But I have all through the police car. But I keep it in my safe deposit box at the bank.
See, I think that's...
Because I didn't know exactly how that law would affect everything. And so for his safety and for him to just be right with the law and me also, I just keep it completely away.
I think that's the best solution for both of you. You know, quite frankly, there'd be nothing that would prohibit you now from applying for and receiving a concealed carry permit. But that would be a separate issue from not allowing access to a convicted felon to get that gun.
Because I have applied for
sure,
it.
Sure. But that's the only thing, that would remain the true with the permit or without it, is I think that anytime there's a presence of a convicted felon, you have to take steps to make sure that you restrict access to that firearm so that, you know, for their sake and for yours. Is the best. Yes, sir. No, we're
If a church posts weapons are not allowed and someone gets hurt on that property, is the church responsible?
Yeah. Now this is an area that has come up many times. So I've talked to all the festival groups, and everybody has deep concerns about that. That's another part of the law that quite frankly, is a little counterintuitive. The law, as it's currently written, provides indemnification or protection for people who don't post. So if you don't post and somebody comes in to do something bad and somebody with a concealed carry permit takes their weapon out and stops that person from doing something bad and somebody accidentally gets hurt, the law protects them. If you're a church group, if you're running a church festival, if you're a private business and you post and then somebody comes in and somebody with a concealed weapon tries to stop that person and somebody gets hurt, I don't know the answer. And quite frankly, that's not my area of expertise. What I would recommend is talking now, if the church has some kind of a corporate board, what I recommend that they do is that they contact their civil attorney and get a brief on that issue, raise that issue. I think the city attorney is willing to talk about that issue because it's a civil liability issue. I do criminal liability. That's my expertise, so I'm really reluctant to weigh in on that. I can tell you, I know exactly what the issue is, but I don't know how it's going to work out in the courts right now. That's something that again, when we talk about tweaking the law, what seems to make sense to me is that you would provide liability protection for the people who post. So if you post, then you should get the protection if somebody against your wishes comes in with a firearm and then hurts somebody in the course of trying to stop somebody from doing something wrong, or both. I would have no problem. Just make it blanket, coverage but include people that post who express a desire. If you post and somebody comes in to your establishment, they are subject to a forfeiture. They're not subject to. It's not. First thing you have to do is you have to give them that. You have to inform them that you don't want them there, and then you have to ask them to leave. If they refuse to do that, you can contact the police. The police can remove the person, but the only penalty for it is what we call forfeiture. It's the equivalent of a ticket. If you go into a prohibited location like a courthouse, then it's a Class C misdemeanor. it's a 30-day, potential 30-day jail sentence that could be attached to that. So that's the distinction right there. But I can't give you a exact answer on what your civil liability is going to be if you post and then somebody uses a concealed firearm in your location. Yes, ma'am.
How do they count it if they take their firearm and put it in their trunk?
In other words,
It's not concealed on their body, but it's...
yeah, you know, we've often told people that that's the safest way to transport a firearm. In other words, the way, if you're not permitted, that's the distinction. If you don't have a permit, the surest way to not get in trouble with the concealed carry law is to not have it accessible. So we generally have people keep it unloaded and keep it in a case that's designed for a firearm, and then put it in their trunk or some area that's inaccessible. Because then they can't. Because then under the law, you're not violating the law by carrying the concealed weapon. So that still remains true today. Now, if you have the permit, you can pretty much carry it any way you want. That means that you can have it openly displayed in your car, on the seat or anything like that. And again, there's nothing wrong with that per se, except thinking about it in sort of a practical sense, and that is, if you encounter a law enforcement officer and they see a gun on the front seat of the car, they're not going to know right away that you're a permitted person, and that's going to cause them some concern. And again, rule number one is they got to protect themselves, and they have to try to control the situation in a safe way. So these are some of these ambiguities that we're trying to work through. Yes, ma'am.
Okay, I have permit, I have everything, and I have to protect myself, and I shoot somebody to protect myself. What's going to happen to me then?
Okay, and this is an excellent question as well, and that goes to my original warning, and that's all it is. It's a warning, and it's the same. But remember, it's the same understanding that every police officer has when they go through this training. The most important decision that they're ever going to have to make is whether they use force and whether the amount of force they're going to use is reasonable. That's true now for any citizen that's going to carry a concealed weapon. Okay, and that means that you know, my urging was if I could come up with a course description of how you are properly trained to carry and potentially use a firearm, it would be go through the NPD firearms training course. You know, get as much training as a police officer gets when they first are trained. That's not realistic, I understand that. But what I also tell people, and what they don't often understand, is that, you know, the training the police officer gets isn't, you know, 90% just firing the gun. You know, just learning how to be proficient at firing the gun. That's an important part of it. But actually, the most important part of the training they get is when they are legally justified to use force. And in Wisconsin, the standard's pretty simple, and that is that a person is justified to use force if they believe themselves or another person is in danger of death or great bodily harm. And even then, they can only use as much force as is reasonable under the circumstances. So when a police officer does it, that's what we're looking at. We look very closely at all the facts and circumstances to determine whether or not the threat they faced was in fact an objectively reasonable threat, and whether they used the appropriate amount of force to terminate that threat. And so the same is now, it's true, and it's always been true for ordinary citizens, but you have to even be more aware of it now if more people are going to be carrying weapons in public. But the reality is that if you are involved in a shooting, and this is true for a police officer as well as anybody else, if you're involved in a shooting and somebody is hurt or fatally wounded, it is going to be treated as a crime scene, and it will be looked at as a homicide scene. You know, that's some of the most difficult discussions I've had with police officers. They all agree to talk to us. You know, this is one agency that has a remarkable history. When they're involved in use of force incidents, they talk to the DA's office sometimes within hours afterwards. You go around the country, most of their police officers won't talk to a prosecutor for 48 hours later. They often talk to me when they're still under the emotional stress of that situation. So I get to see what the impact of this event is on them in real terms. And I get to see, you know, I talk to the victim, or not the victim, but the decedent's family as well. And then I talk to witnesses that same day. And then I go to the medical examiners the very next day, and I sit in on the autopsy. So I see exactly the consequences. To me, it's all very real. I can picture how all of this unfolds. For a person that hasn't been through this and isn't trained to experience it, it's going to be a traumatic event. That's all there is to it. If you're involved, it's likely that you're going to be detained by the police while they question you. They're going to look at witnesses, and we're going to look at it to see if it was a justified use of force. And that's why, I'm not trying to scare people off. I want to inform people. I have to do that. That's my obligation, so that everybody understands what a absolutely critical decision that they're going to make, and what a serious decision it is to use force. That having been said, the same rule always applies, and it's a relatively common sense rule, and that is that if you're presented with a situation where you fear that you're going to suffer death or great bodily harm, you are justified to use appropriate amount of force. And I really, and every situation is absolutely unique. It really is. Every situation is unique, and we treat them that way. And most times, when a person uses that reasonable amount of force, the first people to tell us that are the police officers themselves. They're usually the first ones that'll come to us and say, okay, this is what we've investigated, this is what we found, and it looks like it was a justified shooting, but you take a look at it and you decide what you think as well. Yes, ma'am. I'm sorry, I'll get right back to you.
Are there any weapons that are prohibited under the concealed carry?
No, there really isn't in terms of like particular brands of handgun or anything like that.
Well, like automatics and guns that shoot,
Yeah, no, that's a good question. And the reality is that has not changed at all. In other words, you still cannot possess a fully automatic weapon unless you have what's called a Class 2 ATF license that allows you to own one of those. You can't have a weapon that's been modified beyond the legal length. In other words, like a short-barreled rifle or a short-barreled shotgun. You're not allowed to possess those. You still can't have a switchblade, anything like that. So yes, the traditional weapons that are prohibited still remain the same. Yes, ma'am.
When this whole gun discussion was coming up in Madison, did they consider open carry versus concealed carry?
Yes, and that actually was part of the debate, but the reality is Wisconsin has always allowed open carry. The problem is, it goes back to that discussion that, how I kind of started this discussion, and that is that there's probably the most frequently used law in the state of Wisconsin is 94701. It's disorderly conduct. Anyone who engages in violent, abusive, unreasonably loud, or otherwise disorderly conduct is subject to a Class B misdemeanor. But most local jurisdictions have also incorporated that into their ordinances. So you can get a ticket for a disorderly conduct, which is non-criminal, or if the officer thinks it's appropriate, they can issue a criminal disorderly conduct. In the past, anybody who walked into a public gathering with a gun strapped to their hip or with a shotgun in their hand, they were likely to have been arrested for disorderly conduct, because again, it's a catch-all. The law has now, the guidance that's come out of the Department of Justice is that open carry is allowed in the state of Wisconsin. The problem with that is there are still some circumstances where it'd be so unreasonable for a person to openly carry a firearm that it would probably provoke a pretty strong response from law enforcement. And why is it? It's because in today's world, what just happened in Ohio yesterday? It happens. It happens almost every week, right? Somebody goes into a public location like a school, post office, a business place, and for some period of time they are openly carrying. But the problem is that they openly carry only long enough to start open fire, and so the problem for a law enforcement officer is if you see somebody openly carrying, we still haven't perfected the technology of reading people's minds. And until we do that, it just creates problems for police officers. So most police officers will tell you, if I see a certain, depending on, look, if I'm in the North Woods and I see a guy carrying a shotgun during hunting season, I know what's going on there. Maybe even in some small towns, if I see somebody walking around with their shotgun, I'm not even going to be that worried. If I see a guy walking with a couple pistols on his hips into a shopping center, you know what? It might provoke a response
Yeah, but
just from
this way,
safety.
at least you see it. I'm walking down the street and you've got a gun and you take it out and shoot me, I don't even have a chance.
Now the argument, and that's a great point, but the argument that the proponents of concealed carry would say is that it's always been that way anyways. Is that it's always been, and they would say that at least now there might be somebody that's legally carrying that could try to stop that person as well.
Yeah, but like at Aldi's up here when that happened and that guy, they had it posted, no guns allowed in Aldi's. Now he had a weapon and it was probably a good thing at the time that he had it. But what good are those signs if he stopped a robbery and it was probably a good thing and nobody got killed, somebody got shot. It was probably a good thing he had his gun on him. But they had it posted.
They did. And that's one thing that we looked at, quite frankly. But also keep in mind that under Wisconsin law, even a convicted felon, under certain circumstances, is allowed to use a firearm to stop somebody from killing somebody else or committing an act like an armed robbery.
I thought you
And
said
so-
a felon wasn't supposed to have a gun.
They can't, under any circumstances. But what the law says is they're privileged for that short period of time to use a firearm to save their life or to save somebody else's life. The case is, if you want to look it up, it's called Coleman, State versus Coleman. Yeah, but it's, that's what I'm saying. It's always complicated. It really is, and that's why each case has to be looked at individually. That's a great example. I mean, that is actually a great example. The person involved in that had a pretty extensive history. Okay, he had a pretty extensive history of juvenile felony offenses that occurred before the law was changed so that he was not prohibited from having firearms when he was adult. There had been instances where we suspected that he had been furnishing firearms to gang members. And so, that was part of his history. I know that because I was looking at some of those cases in about 2000 or so. Okay, so it's not, but the law is the law, and he's now allowed to have firearms, and he was actually permitted at the time. It's interesting, the posting at the Aldi's was probably not prominent enough. He said that he never saw the sign, and some of the investigators that looked at it, they had the same concerns that you have, and they brought the case and asked me to potentially charge him for that. I elected not to, and again, I do it on a case-by-case basis. I elected not to do it in this case because I thought particularly reviewing the video, I thought that he had actually acted reasonably under the circumstances. He took certain steps, like for example, the first thing he did was he grabbed his wife and he moved her out of the way, got her into a position of cover. He then positioned himself so that he wasn't in the direct line of fire of any of the citizens in the Aldi's. In other words, he actually exposed himself while doing this, and then he waited until the guy was leaving and was just a short distance before he pulled his gun and started firing. And interesting enough, it goes back to that training issue. If you look at the video of this, when he pulls that gun out, you can see very distinctly, and he even admitted afterwards, he was going like this at the guy. Guess what he was doing? He forgot to take the safety off. Forgot to take the safety off.
That's the main point.
You know what? A police officer goes through the training that they go through because when they encounter these situations, they happen just like this. And just that split-second hesitation can cause, life-changing consequences. So, but I looked at all those factors, and in the end, I decided that he acted reasonably enough. And you're right. Would it have been a different assessment if while firing, he had hit an innocent person? Yeah, it would have. It would have been a different assessment then. I don't know that I would have charged him or not charged him, but I know that it would have been, if he had actually killed somebody in the course of doing this, it would have been a very different assessment. But that's why we base it on a case-by-case, fact-by-fact basis. And that's also why you have to just take it so seriously and make sure that that you use sound judgment each and every time. That's a great point.